Good afternoon, everybody, and welcome to this panel on space law policy and the SSA Regulatory Framework. It's clear, listening to the conference over the past couple of days, that this subject has penetrated many of the previous panels, and so it just reveals the centrality of the emerging ethics, law, and regulatory frameworks in managing the near-Earth orbital domain and in space sustainability more broadly. Today, we're privileged to have two of the foremost experts in this field to enlighten us and to answer your questions. So please remember to post your questions in the live Q&A box on the right-hand side of your screen there. We're going to start by taking a broad view of the area, and I'm delighted to introduce Professor Chris Newman. Chris is Professor of Space and Law at Northumbria University and visiting Professor in Space Law at the Open University. He's published widely on legal and ethical underpinnings of space governance, including co-producing the book Frontiers of Space Risk. His transdisciplinary approach means he's familiar to most of us who are familiar with his boundless energy and positivity, and as a leading light on the subject of space law. So without further ado, I would like to welcome Chris, and we look forward to hearing your presentation and to answering some questions later. Chris.
Thank you very much indeed, Mark. That's a really generous and wonderful introduction, and it's my privilege and pleasure to be here. I was part of a panel yesterday that was just fantastic, and today I am the hors d'oeuvres, and we've got one of the world's leading space lawyers coming up as well, and we're going to really try and get into what space law and policy can and cannot do. I think there's one of the things I'm trying to do, one of the things that my work has sort of become, if you like, is a bit of an explanation of the limits of law and the limits of the way in which the law can actually work. I now start to talk, those of you that have worked with me and those of you that have sort of seen me before will know that I've worked very much in the field of governance rather than law. Law is an aspect of what we're going to try and do, but it's not just the sole aspect of it. And what we're going to talk about today is some of those levers that we can pull on to try and influence change. There's a lot of assumptions that I think are implicit. There's a lot of assumptions that go on. I'm going to try and challenge them. I'm going to work with you to unpack some of them. I'm hopefully also going to, yesterday I was talking about collaboration. I'm hopefully going to show the value of collaborating with somebody in this discipline on this area, because I think we can add value. We can add value to your projects by showing that we're thinking about a bigger picture than just the technical, just the engineering, just the product that you want at the end of it. There are significant challenges. Let's not, sort of shy away from that. One of the things that I always find really invigorating about conferences like this is people are not afraid to discuss the problems that we're facing in a relatively collegiate and sort of, coordinated manner. We know what the problems are, and we're getting to the point now where we're going to need solutions. We could have had this discussion 10 years ago, and there wasn't quite the urgency on it. Yes, we'd had Iridium Cosmos, but Iridium Cosmos, that's now, 10, 11 years ago, and it slipped into the dim and distant memory. And, but right now we have a number of key events that are occurring that we need to address, that we need to start getting ahead of. I'm going to talk about some key principles in space governance, and then I'm going to talk about SSA, SST within a legal and geopolitical context, what we can do and what we can't do. Because I'm going to lay out for you 3 potential models of space traffic management. And I'm going to point out the advantages and the disadvantages of each of them, what they mean and how possible they are. And funnily enough, the requirements of the one that is the most onerous is also the least likely to be achieved. So what we're going to do is we're going to do a little bit of legal mechanics right now. We're going to look at the law. We're going to look at how the law is comprised. We're going to unpick that and look at the way in which law is a small element of what we do. Then we're going to talk about, okay, if we are going to try and coordinate our activities, and there's a number of questions there implicit in that statement, which I'll come back to as well. How do we do this? I say this every time. This is sort of my mission statement to every conference that I give. And I actually did it to a law conference the other week as well, because this is something that I find lawyers, as much as anybody, tend to forget this. It's one of the things we forget. We talk about regulation, we talk about laws, we talk about governance, we talk about codes of conduct as if they're the same thing, and they're very much not. They very much differ in what they're trying to do, in what they're trying to accomplish, and in how they can accomplish those goals. Laws, we know what a law is. We can recognize that. It's a command backed by the threat of a sanction. If you go 31 miles an hour in a 30-mile-an-hour zone, you're going to get some points on your license. If you kill somebody, you are going to go into jail. And those are sort of primary rules of behavior. They're also underpinned by secondary rules, which allow those primary rules to be recognized, changed, and adjudicated upon. So, for example, if I claim that the speedo in my car wasn't working properly, we go to before an adjudicator. We call that adjudicator a judge, and it happens in a court. So we know what laws do, and we know that enforcement is relatively predictable, and we see it manifest. We see sentences being passed down, or we see not guilty verdicts. Regulation, this is slightly different, because regulation is concerned usually, almost always, with a specific activity. So let's go back to the car analogy. Driving is regulated. We have the DVLA, which regulates the way in which vehicles are dealt with, which regulates the way in which drivers are dealt with. Drivers, like space operators, are licensed. We have to prove our competency. We then get issued with a license. If we act out with that license, we're liable for a criminal offense. Okay, but the regulator's primary concern is of safety of that activity. Whereas with a court or a tribunal, they're interested in a just result. One thing I haven't mentioned there is international treaties. Yeah, international treaties are basically contracts between states. They can be a contract between state A and state B. They can be a contract between state A, B, C, D. They can be, in the case of the Outer Space Treaty, a contract between 110 states, all saying we're going to behave in a certain way. We're going to take on these obligations. So they all have a legal feel to them. Certainly laws will have legal force. Regulation will usually, in the UK, I'm talking about the UK here. In America, it's exactly the same. In Australia, it's the same. You know, in other countries, it's broadly similar. Regulation will have the force of law because it'll require a law to bring in the regulatory framework. So, for example, if we want to launch a spacecraft from the UK, we need to empower a regulator to issue a license. We need to empower a regulator to, certify a spaceport, certify range safety, etc., etc. So we bring in the Space Industry Act 2018. That then puts in place the regulation. So it's kind of, it's this matrix of involvement. Where we differ, and where we're going to talk about at the end, codes of conduct, guidelines, these have no legal authority. Now, they can be given legal authority, because if a regulator says you must comply with those guidelines, they stop being guidelines and they start being a requirement of your license. So there is a way we can get enforcement, but it's very narrowly drawn. Normally, guidelines are there to nudge behavior. You'll hear a lot of talk. It's something I've noticed in the last sort of 3 or 4 years. Norms have become the soup du jour of influencing change in space. Let's create new norms. Let's find some norms, right? Well, norms actually are there. They're not something we can create. They are there. They're manifest. Yet we identify norms. We say, what's happening? What is best practice? What are people doing? Right. That's a norm of behavior. Norms can be political. Yeah, the government wants you to pursue that policy, so everyone starts doing it. It becomes normative. They can be legal, and they can be cultural. So again, there's a whole range of language that I'm finding creeping into the use of space law. We just need to be careful what we're saying and what we're asking for. Yeah, are we asking for regulation? Are we asking for new laws? Are we asking for new treaties? Are we asking for norms of behavior? Are we asking for a combination of all of them? Each one of them does a very different thing within law. So we have to think about what the end is we're trying to achieve. Are we trying to achieve, a regimented traffic system? Well, if we are, we're going to need a combination of regulations, laws, guidelines? We're going to need a combination of all of it. Are we trying to coordinate the flow of data? Well, that's much more guideline. That's much more voluntary, but with perhaps international agreements overlaying that as well. So my first thought is, let's think about what we want to actually achieve. Let's think about what we want to do and see the best tool to do it. Because we have our pyramid of space governance. Again, those of you that have seen me before, I apologize for shamelessly plagiarizing myself, but I learned how to do a pyramid on Microsoft PowerPoint, and I'm going to use it until I get sick of it myself. Top of the pyramid, we have the international obligations, the Outer Space Treaty, the Rescue Agreement, Registration Convention, Liability Convention. Then we have the domestic regulation. In order to satisfy those international obligations, the government needs to lay down laws which make sure that the regulators behave in a certain way, that space operators behave in a certain way, etc., etc. So we have domestic regulation, which makes the whole thing tick. And then underneath that, we have what I've said before, these non-binding mechanisms, these sector-specific guidelines. So the UN debris mitigation guidelines, they can be incorporated by the regulator. The regulator could require post-mission disposal of 25 years. So they get drawn into the legal framework that way. I'm not going to talk too much about the Outer Space Treaty, which will be a merciful release to a lot of you who've heard me talk about this for quite some time. But it is the central trunk of outer space law. Still, right now, the first question that we always ask when we're thinking about space activity and we're thinking about the legality of space activity, first question we ask, what does the Outer Space Treaty say? That shows what a powerful treaty it actually is. And that's my first warning sign. I'm going to sort of flash up a warning beacon here, because there are those who, for very good reasons, are advocating opening the Outer Space Treaty up. I'm going to use this phrase. I've used it before. Some of you will be smiling because you know what's coming. It's the Humpty Dumpty Treaty. Because once it falls off, once it's opened up, all the king's horses and all the king's men will not be able to put together the agreements that we got in 1967. Right? It's binding on over 100 nations. It imposes behavioral requirements. Those behavioral requirements might not go far enough. But then we have the state accountability framework, what I call the accountability triangle. Article 6, international responsibility. Yeah, international responsibility for space activities lying with the nation. Then we have liability and this new concept of a launching state, distinct from the Article 6 responsibility, a launching state. If you're putting stuff up there, then you're going to be liable for damage caused by space objects, either on the surface of the Earth to aircraft in flight or to anywhere other than the surface of the Earth or aircraft in flight, which is everywhere else. And then incentivization of registration, the requirement of a registration scheme by giving jurisdiction and control to states who register space objects. Then we come to Article 9. Article 9 is a bit of a hodgepodge. Longest tries and nods to environmentalism. It introduces a principle well known in international law, that of due regard for other space, the space activity of other states, and tries to prevent contamination of the Earth by alien space bugs and whatever. And one thing that I really want to flag up is this notion of liability. Liability lies A, with the state, and B, it is contingent on a number of factors happening. Firstly, there's got to be a launching state. Okay, that space object has got to be tied to a launching state. Then we look at where the activity occurred and where the damage occurred, damage on Earth and airspace. We have this concept in law, which is very, very rare, of absolute liability. We don't need to show fault. All we need to show is causation. Your satellite landed on my property, caused damage. I don't care how. I don't care if you were the unluckiest person in the world. You are absolutely liable. Okay? I don't care what mitigating factors intervened. If your object causes damage to my house, then you're paying for it. Okay? Your state is liable. The Liability Convention Article 3 is slightly different. For on-orbit operations, it's slightly different. Damage elsewhere other than the surface of the Earth or airspace, it's damage caused. So again, we've got to prove causation, which is not an easy thing. By a space object of one launching state to another will arise only if the damage is due to the launching state's fault or the fault of persons for whom it's responsible. So we introduce fault here. And again, proving fault. How do you go about proving fault? Well, in law, we look at, is there a duty of care owed? You know, is that duty being breached? Would, you know, is the consequential damage a result of that breach of duty? So we're into the law of tort. Because we know that if a satellite's damaged in orbit, the economic, political, strategic implications are going to be significant. Okay. And there is no litigation as yet to test the limits of this liability regime. I know Joanne, who's going to talk in it. This is something that we haven't seen before. We don't know what litigation is going to look like. We know that it's going to be on a fault basis under Article 3. But usually fault is because of a lack of compliance of a treaty obligation, a breach of duty of care, a failure to comply with codes of conduct or norm. The court's going to look across the piece and say, was that behavior the behavior of a reasonable spacecraft operator? And there's little in the way of these normative rules to point to, because each individual operator will have its own protocols, will have its own way of working. And there is no systemic way of managing space traffic at the minute. So I've talked about the international dimension, the treaty obligations, the treaty aspect of liability. I'm going to go down a stage down for the pyramid now. We're going to look at national laws. Well, I've kind of already said why these exist. They exist because states have said, yeah, we're going to authorize space activity. We're going to license it. We're going to supervise it. If we launch something, we're going to be liable for it. So we're going to want to think about what that means for our taxpayer, because space missions can be very expensive and they can cause a lot of damage. So we're going to think about liability both to the taxpayer and to the industry as well. We're going to think about our registration obligations. So the UK, since 1986, has established, well, actually, I think it came into force in 1989, but it came on the statute books in 86, established a licensing mechanism. And it was criticized as being particularly onerous because it required unlimited third-party liability before granting a license. But the government are going to say, well, we're just protecting our taxpayer. Why should they foot the bill? And other jurisdictions have pressed ahead with this. Now, there's lots and lots of space law on the UN Office of Outer Space Affairs. They've got a website which talks about this. But interestingly enough, there is no bespoke legislation for space traffic management or space situational awareness. So no exemplar regime exists. Yes, we have a presidential directive signed by the former president of the United States about space traffic management and space situational awareness, but that didn't result in legislative activity. The legislature did not act upon that executive guidance. So at the minute, there's no real regime for this. And there's a number of problems we've got here when we're thinking about SSA, when we're thinking about making people or making states do it. Because more and more states want to get involved. And if you're trying to build laws, the more people get involved, the more you end up with the camel, the horse built by committee. Because the busier space gets, the more likely it is there'll be satellite collisions. Now, the sky isn't, this is one of the things that I've talked about a number of bit. The sky isn't necessarily falling in, but there are more and more users. There are more and more operators up there. There are more and more stakeholders, each with their own desires and their own needs and their own requirements. And they're going to come into conflict. Nations want to control the space environment. So we know that governments have said they want this. You know, we see the UK Space Agency has a dedicated cell for this. But that's limited by the fact they don't want any other state to do it. So whatever the UK wants, if China doesn't want it, or if the USA doesn't want it, we know the realpolitik of the situation means it probably isn't going to happen. It's not going to happen by a treaty. I'm going to make a statement now. I think I'm on fairly solid ground saying this, but I don't foresee another international treaty for quite some time, because they're time consuming, they're hard to negotiate, they're very narrowing. You know, they fix a point in time. This was the great strength of the Outer Space Treaty. It fixed it at a particular point, and it fixed it at a point where states were willing for the UN to have a greater role and a greater say. That's not the world we live in now. So the geopolitics is different. The institutional respect and the institutional esteem is different. And all of this means that negotiating an international treaty, we only need to look for environmental law for how difficult it is to get some guidance and get some sort of management of the Earth's environment. Companies want lightest touch. Governments are quite happy to do it, but they don't want anybody else to do it, but it's an international venture. So how is this managed? National regulators can only control and supervise national activity. So basically what we have is we're talking about two distinct systems of law. We're talking about a vertical legal system, domestic regulation of space activity. Yeah, Parliament at the top, regulators grant the law, grant the license, courts punishment for non-licensed activities, and operators apply for the license and are bound by the courts and are bound by the act. But in an international system, it's a horizontal system. States will recognize no sovereign authority. They won't be bound by others. And so what we have is compromise and negotiation. Now, right now, the geopolitics of the situation means that the price of consensus is very, very high. So what we have instead are these guidelines and codes of practice, because sometimes states are willing to engage in discussions and they're willing to get together and they're willing to negotiate, but not at a treaty level. They're not willing to bind themselves as a nation, but they are willing to engage in a non-binding, non-legal fashion. Okay, so in lieu of an international treaty, these guidelines, these codes of practice provide best practice, which can lead to identifications of norms of behavior. They can start shaping behavior. And we've got a whole range of guidelines that are out there that you'll be familiar with: debris mitigation guidelines, ISO standards, COSPAR, planetary protection. So the advantages of these is that they are usually done by experts. So there's less of the diplomatic posturing. They're flexible. They're responsive to ambient changes in technology. They're less cumbersome. And because states aren't putting, treaty level agreements in place, states say, yeah, we'll try and abide by this. With these guidelines look reasonable to us. Of course, the big disadvantage is the one that you know. What happens if a state says, get lost? I'm not doing that. There's problems there. So this is the ultimate trade-off. You can get something, and that something will be a creature of compromise, and it may not be binding, but at least it's shaping behavior. What I want to talk to you about, and what I know that's really important to both me and Joanne in this, is the guidelines for the long-term sustainability of outer space activities. And I've pulled some quotes out of the guidelines because I think they're really important in showing what they do. A compendium of internationally recognized measures for and commitments to ensuring the long-term sustainability of outer space activities, and in particular, enhancing the safety of space operations. It gives us a definition of sustainability. I won't talk about that in a minute, but it's nice to know that there is one in existence now, because sustainability is one of those words that it almost like the old Yes Minister joke. You get rid of the difficult bit in the title. If you say something sustainable, you hope that people won't look underneath that and actually, realize that it might not be quite as sustainable as you hope. So we've got a definition here of what sustainability looks like. The purpose of the guidelines is to assist states and international governmental organizations, both collectively and individually, to mitigate risks associated with the conduct of outer space activities so that present benefits can be sustained and future opportunities realized. These are really significant, and I know Joanne's going to go on and talk about them, so I'm not going to say anything else. So my question is, and this is where I'm going to finish up now because I know that time is short, where should space traffic management sit? Well, bearing in mind what we've said, you've got a range of options. And I'm going to give you my three options: the high regulation, the medium regulation, and the low regulation. Now, each one of these has trade-offs. The high regulation sounds superficially attractive, but don't get suckered into wanting it too much, because I'll tell you why it's a disadvantage as well. We get an overarching body in charge of authorization and allocation of orbital slots. It requires a new set of binding rules, regulations. It requires an operating authority. It will undoubtedly require an international treaty. It has the power to punish, the power to say to a country, you are going to lose 2 orbital slots, and we're going to give that one instead as a punishment for you. The power to insist on things like retroreflectors, GPS, etc., so we can better understand the orbital environment. Require and mandate collision avoidance maneuvers. The information flow is largely one way. It is operators telling the regulators what they're doing, and this overarching body directing the Wizard of Oz, if you like, the person behind the curtain. What's the disadvantage? The disadvantage is this is phenomenally expensive, and it's going to be phenomenally difficult to get agreement on. Which state is going to be the one that enforces the punishment for poor practice? Which, is America really going to give up orbital slots if an international regulator tells it thinks it's done wrong? I think not. But effectively, that's your orbital policeman right there. So, okay, that's your high regulation. Your medium regulation, it works with national regulators harmonizing standard responses based on information sharing and transparency, and incentivizing best data, issuing advice, possibly nudging operators in the direction of, well, you might want to do this, built on consensus using guidelines, standards, these softer, non-legal, non-binding agreements that builds up a pattern of behavior. The Space Traffic Management Clearinghouse, which is built on existing institutions. No power to compel, but the ignoring of advice would be persuasive of fault, and it's going to be paid for by the government, so we're going to pay for it, taxpayers. And then we have low regulation, which is basically what we've got now. CSPOC provides data. National regulators say, okay, that's too many satellites, so we won't put them up there. If you don't behave, we won't give you a launch license. We have insurance to act as a backstop. You can get commercially enhanced data, but that's going to be a luxury option. And operators say, well, actually, we're using space, so we're going to determine the best way to manage our assets. I'm going to stop there because I'm cautious of running over time and what that we've got Joanne to speak anyway. But Mark, I hope that was useful. I hope that was interesting for everyone.
Thank you, Chris. That was fascinating. Every time I hear you talk, I learn something new, and it is like peeling the inevitable onion. That there's continual layers beneath them all, and it's fascinating stuff. I'd now like to move on to our next speaker, Joanne Wheeler. Joanne is I would argue, the leading expert in the field of satellite regulation and commercial contracts. Joanne won the FT, the Financial Times European Legal Innovator of the Year, for her work with the UK space industry. And since 1999, she has been the main lawyer involved in the ISO space debris standards. She's a managing partner at Alden Legal and chair of the Satellite Finance Network. Joanne is too modest to admit, but at every turn on the subject of space law regulation, Joanne's name comes up as the authority and is quoted across the board. So it is my great pleasure to introduce Joanne and hand the stage over to her to hear her point on some of the space regulation as it applies to SSA. Joanne, over to you.
Thank you so much, Mark. That is an embarrassingly kind introduction, but it's great to be here. And thank you so much to the organisers and Catherine Courtney for inviting me. And it's great to be doing a double act with Chris. And thank you to yourself, Mark. I thought I would just follow on from Chrissy's, as normal, excellent presentation by looking a little bit at the changing orbital environment, because actually the issue of environmental sustainability, when I started off in the British Standards Institute back in 1999, seems a long time ago. The orbital environment was very, very different than it is now. And we need flexibility in the guidelines, but also in national implementation. That takes me to the anticipatory approach to regulation at national level, the approach of the UK, which is a pretty robust, thought-leading one internationally. And then some proposals that I would like to suggest in regard to what's called the race to the top, and the link of the sustainability guidelines into environmental and social corporate governance to ensure that these LTS guidelines can actually be implemented in practice. So to quote Simonetta de People, the director of UNOSA, in a fantastic conference earlier on this year, global space sector is moving faster than we could have imagined. There are over 80 space programs at the moment, and 83 states now involved in space activity, and this figure will only grow. Government expenditure is, interestingly enough, amount to only 20% now of space expenditure. And I just think 20 years ago, when fundamentally the programs were government-based. But that growth in commercial activities and orbital populations has an inevitable effect on the sustainability of long-term space activities. And the dynamics of space are changing. Just think about the aspiring new space nations joining the international community, new categories of non-state actors, large industry players, startups, universities, now joining this international community, and the advent of large constellations, CubeSats, small launch facilities, etc. But I feel strongly that to manage this, and to echo what Chris has also just said, there is no substitute for an international, multi-stakeholder, multidisciplinary approach to create a level playing field dedicated to sustainability in space. Now, I'm not going to go too much into the small print either of the law behind this. I'm going to use what I sometimes do with 4 words, which I think is all we almost need here. And as Chris has touched on, and it's important to just the baseline really, states are responsible for their national activities in outer space, and therefore they are obliged to authorize and continually supervise those activities. And also put in procedures actually when those activities stop potentially. Liability, now we're seeing more and more varieties of launchers, but if a state launches or procures a launch of a satellite, or from whose territory or facility it's launched from, is internationally liable. Once a launching state, always a launching state. And as for jurisdiction and control, if an object is placed in a national registry, the state has jurisdiction and control for what goes up, stays up, and what comes down. And that ownership is not affected by the presence of that object in space. Now, I spend a lot of my life saying that outer space is special and needs different treatment. But here, I'm going to argue that outer space is not special. I don't want the concept of the environmental protection to be out of sight, out of mind when we come to space. We need to take responsibility for space, as we are now trying to do more than ever on Earth from an environmental perspective. So I would strongly argue that outer space environment is not something separate or something different from the concept of terrestrial environmental law. And what's important is stated in the Outer Space Treaty here that exploration and use of outer space should be carried out in accordance with the international law that we put in place down on the ground here. The principles of general environmental law are relevant to space. And that includes this concept of a duty of the state not to permit the use of its territory to the detriment of another state, which has come up in the Climate Change Convention. But importantly, environmental damage can also be caused without the territory or property or personnel of another state being involved. Damage can be done to environmental areas not owned by a state, beyond the jurisdiction of a state. Think of the high seas, Antarctica, and outer space. Now, space, of course, is beyond the limits of national jurisdiction. I want to give an analogy of, I spent 5 years, best job ever, at European Space Agency. And when I was at ESA, I was in an international meeting with all of the players from the International Space Station. And I was put on the spot. I was the only lawyer in the room. And I was put on the spot to explain what international space rules covered the issue of space debris, because an issue had arisen with the space shuttle being safely brought down to Earth. And could weight on the space shuttle be jettisoned to protect human life? Now, one would argue human life takes over everything, but what about the issues of space debris? And I was put on the spot then to explain to all of the members of the International Space Station what would happen if various aspects, equipment on the shuttle was going to be jettisoned out in outer space. So I mentioned, echoing Chris too, that outer space treaties do not mention space debris. They don't mention it once. It's not in any international treaty. What I base my arguments in regard to protecting outer space and the mitigation of space debris was international environmental law. And this Principle 21 of the Stockholm Declaration states have a responsibility to ensure that activities within their control, that they can control, do not cause damage to the environment of areas beyond the limits of national jurisdiction. So that covered outer space. Principle 22 also encourages states to cooperate in developing international laws to liability and compensation for damage caused by activities within their jurisdiction or control to states beyond their jurisdiction. And that language is found in several other UN treaties and statements. But as Chris has mentioned, these declarations and statements aren't binding. So what else do we have to look on? So we've got international environmental law, we've got the Stockholm Principle, but there's no concept of an international crime for pollution out of space that doesn't exist. There's this concept of exceptionally serious wrongful act. Oh goodness, I would not want to stand up in court and argue what exceptionally serious or wrongful meant in this concept. A general international duty towards the preservation and conservation of the environment, yes, I would strongly argue that that extends to space. There's a precautionary principle that better to be safe than sorry in favour of international environmental duties to prevent pollution, and that's developing in space law. And there's a duty to respect and manage the environment of the global commons, and that can also now be inferred from terrestrial international environmental law. And I love this concept. The International Court of Justice discussed the harm of to generations unborn. And this could include, I would argue, the degradation of the space environment. I love the concept of generations unborn, the next generations. But all of these declarations and statements are non-binding. They have been enough, I have found, for solid international arguments to stop pollution, stop harmful interference, etc. And I have used them to death, but they are non-binding. But therefore, what I'm trying to say here is it's great to have international guidelines, and it's great to have that solidarity at international level, but really the implementation of these guidelines and these statements at national level and in agency contracts is absolutely key. And I would argue states need to exercise due diligence on licensees as responsible states in framing and enforcing their laws and regulations and licensing conditions to secure the space environment. Now, I've got another triangle diagram a bit similar to Chrissy's, slightly different. This just sets out actually really the importance of national application. The blue at the top are the international level non-binding standards, etc. And it just echoes the need to enforce them. So you've got the UN guidelines and the 7 guidelines at the top. You've got international best practices just down from that, including the LTS guidelines. But for them to be implemented, they need to be implemented in space agency policies and brought in mandatory requirements for agency policies or for government entities, particularly if they're procuring contracts, etc., or implemented international space legislation, a bit like the French have done. But if they're not provided in national legislation, the debris mitigation measures remain voluntary. If they are brought into national space legislation, they become legally binding. So it's incredibly important that regional bodies, space agencies, and national regulators look to make some of these guidelines binding in national law, policy, regulations, and licensing conditions. Just to echo the importance of this, let me take the 7 UN space debris mitigation guidelines. Let me take 2 of them in particular. The duty to minimize the potential for breakups during the operational phase, minimize accidental breakups. And then number 6, limit the long-term presence in LEO region after the end of the mission. Now let's apply these to actually large constellation challenges at the moment. So I've mentioned number 2, minimize potential for breakups during the operational phase. But it's almost the nature of the sheer tens of thousands of satellites that are going to be launched into LEO that there will be an increase in the number of in-orbit failures. Therefore, we need to look at this level playing field of space debris mitigation measures and application in national law. And let me take number 6, limit the long-term presence in LEO region after the end of the mission. But again, the crowding of LEO orbits with debris over time, particularly with satellites potentially without propulsion, for example. So almost by the nature of these tens of thousands of satellites that are going to be launched, I heard a stat of 109,000 satellites launched by 2030. Let's see. So, example of national implementation in relation to the guidelines for long-term sustainability of outer space. So they were adopted in June 2019, and they provide guidance on policy, regulatory framework for space activities, safety, international cooperation, capacity building and awareness, and research and development. But they are a little bit of the lowest common denominator. They're welcome and they're a good start, and as Chris said, they shape behaviour. And the UN Committee on COPUOS encourages states and organisations to voluntarily take measures to ensure that the guidelines are implemented to the greatest extent feasible and practical. But this, I would argue, really depends on the particular state that is implementing them as to how well that state can implement them reasonably, feasibly, and practical. So let me just touch on the approach of the UK. So I'm quoting the LTS guidelines A3 here. So it says, in supervising space activities of commercial private operators, states need to ensure that those entities have appropriate structures and procedures for planning and conducting the space activities in a manner that supports the objective of enhancing the long-term sustainability of our space, and the means to comply with relevant national and international regulatory frameworks. How would I interpret that into practice? So I would argue that in supervising private commercial space activities, states regulators need to ensure that entities have the appropriate corporate, commercial, technical structures and procedures in place for conducting their space activities safely and securely. They also have the structures and procedures to support the objective of long-term sustainability, and I'll come on to that. And they also have the means to meet their license obligations, etc., on a financial basis, management basis, and comply with the national and international regulatory frameworks. Now, a few of you have seen my cheese board, which is the approach the UK would tend to take in relation to the Space Industry Act and previously the Outer Space Act. And actually, the UK pretty much applies the LTS guidelines now and balances the government risk, safety, security, and sustainable use of space with, we mustn't avoid this, of course, encouragement of commercialization, innovation, and growth. By looking at compliance with international European law, insurance obligations, make sure that license applicants can actually maintain the financial and corporate standing, and then right through to space debris and sustainability guidelines. And the CEA will apply this appropriately, looking at, can the applicant safely conduct their launch into orbit of the vehicle and the payload, understanding the hazards involved? Can the evidence that the operations will be performed safely and sustainably, that there will be no commercial launch operations that pose an unacceptable risk to the public, that they really understand the considerations for liability risk, the probability of collision, the likelihood of a damage claim, or even the quantum of the damage claim, and the operational considerations for in-orbit phase assessment, the ejection phase, the orbit raising phase, the constellation management, and looking at in-orbit servicing, for example. But I have to bring everyone down to earth because the world is not a perfect place in regard to national implementation. It's not that easy. There are increasing amounts of forum shopping. Now, if someone asked me about forum shopping about 8 years ago, I would say there was very, very little. Now it's huge. Companies are selecting the best place to establish based on the ease of access to spectrum and licensing. Next to tax, it's the biggest issue for forum shopping. Therefore, if the regulations are too strict and assessments are too strict, it will encourage what I would class as the race to the bottom and a possible competitive disadvantage to companies that might face the more rigorous regulations. So how do states and regulators really try to incentivize companies to comply with international sustainability requirements? How do we encourage this race to the top? How do we enforce the pledge that the G7 leaders in Cornwall stated to tackle the growing hazard of space debris? And let me make a proposal here. This concept of race to the top, a situation where competition between entities to be the best, to attract investment, to be the most responsible leads to a better performance or outcome. Now, increasingly, you cannot pick up the Sunday papers without seeing this concept of environmental and social and corporate governance. And it's now seen as being integrated to sound corporate and investment strategy, risk management, and you've all seen the promotion of ethical, responsible, environmentally sustainable investment. And clear regulatory procedures and credible licensing regime meeting sustainable goals can and is assisting raising finance. Now, I would argue that actually what I'm seeing in the last few years is not the desire for light touch regulation, but the desire, particularly for larger companies seeking to raise a lot of investment and have an international approach and influence. They want a credible regulatory regime with an international reputation and acceptance and management of space debris. They do want a streamlined license application process and not too significant fees. And interestingly enough, I am now seeing this linked to access to satellite operations licensing in other countries and terrestrial telecoms licensing in other countries, particularly US. And let me give you an exact quote. And this is from a US terrestrial license. This license grant is based upon a finding that X company is and will be subject to the direct and effective regulation by the UK or another equivalent state concerning orbital debris mitigation, i.e. you sort yourself out and be liable and conduct your activities in accordance with orbital debris mitigation. And if a country like the UK takes on that liability, we will grant you the terrestrial license across the US. That's a really interesting dynamic. It's also led to companies needing a stronger voice in international fora, maybe influencing spectrum, maybe influencing access to licenses, and also regulatory diplomacy. Potentially it leads to lower insurance requirements because of the responsibility nature. And we'll see that in UK rollout of the MIR concept for launch insurance. And very importantly, that credible regulatory regime can be linked to finance and the requirements of investors and more and different and larger investments looking to come into this area, but they want to invest in responsible companies. So in conclusion, we are slowly seeing international recognition of the best practice approaches, things like the LTS guidelines, but the guidelines are important for setting an international policy agenda, but they're voluntary and their effectiveness is limited by the success of national implementation. But at national level, luckily, there is a growing acceptance of the need for shaping responsible behaviour and the need to implement such guidelines. Link those guidelines then to a credible licensing regime meeting sustainable goals and linked to raising finance. And interestingly enough, a paper that the UN Environmental Programme Finance Initiative commissioned, actually from a UK company, stated that it is part of the company's fiduciary duty to integrate the ESG issues into its investment analysis. Now, if we can link that into the license from the UK or other responsible countries being a stamp of approval, that increases forum shopping for those internationally recognised licenses. But we still need to look at the effective, proportionate, transparent, streamlined regulatory framework as an enabler for that raising investment. I hope the UK continues its thought leadership in this area. I very much appreciated the UK's sponsorship of the LTS guidelines this year. But the LTS guidelines are a start. As I said, they're limited by the success of national implementation. They are a lowest common denominator. We need to go further, but it's a start. It's a very important start. But let's look now to that overall ecosystem of the international guidelines, a level playing field internationally, national implementation to ensure this commercial, environmental, social, corporate governance linked to investment. I think that's a very powerful message. Thank you so much, Mark. Thank you.
Again, fascinating. And I think if the UK has thought leadership in this subject, you're very much at the front of thoughts on it as well. We've had a few questions come in. I'll lead with one from Chris Dawn, who asks whether, and I'll paraphrase his question if he doesn't mind, what's to stop companies who might have been behaving badly in space or subject to liability, simply disappearing and then re-emerging as another company? How does the licensing regime manage with that sort of behaviours and approach from some commercial operators?
Shall I jump into this one very quickly?
Yeah, it's probably aimed at you a bit more, that one, Joanne.
I have actually seen this, so it's actually a valid question. I have actually seen that issue in regard to launch license. Company disappeared, reformed, 6 months later it was applying for a license, but it still needs to go through that licensing process, and the checks, that cheese board checks, each one of them needs to be applied to, and the mere modelled insurance requirement analysis still needs to be gone through. So quite honestly, they can disappear and come back 6 months later with a new name, a new company number, but they still need to meet these criteria. Increasingly, though, the UK is looking at the management and the financial standing of companies. The French have been looking at the management of these companies for some time, but the UK are now increasingly looking at financial standing and management, and I think that's rightly so. Yeah.
John, you talked about the CA and the structures and procedures that they will be looking to apply. That suggests an understanding of the space environment that is quite detailed. And linking to Chris's point about liability when he was talking about in there, do you think we have sufficient information to begin to apply a credible licensing regime, or implement some of the behaviours we've been talking about more broadly and internationally?
So do we in the UK have enough to be able to implement? I have to say the UK are a thought leader in implementing the guidelines, whether it's IEDC, the ISO standards, the LTS guidelines, and the sponsorship this year. So the only issue there is, however, I should state, at UNCOPIO's level, the legal subcommittee, space debris, as Chris would know, has only been a recent addition to the agenda. It's been on the agenda of the science and technical for some time. And a lot of states would argue that actually we need more scientific and technical assessments before we really understand the risk, the probability of risk, and the quantum of risk for space debris. And we need some flexibility in the approach and some flexibility to the regulators, quite honestly, because the orbital populations and environments are changing very, very fast. And I'm not sure if it's going to be 109,000 launched in the next 10 years or not, but it's going to be several tens of thousands, I think.
Mm-hmm. Yeah. Chris, any thoughts in terms of understanding the environment and begin to apply that to how the laws are understood in the environment and how they might be applied to the tort example you referred to earlier is what I'm particularly thinking about.
Yeah, absolutely. I think what we are at a stage where we don't see how this ends. You know, we are, if you like, in the 1920s of more fields. We can't see how the system ends. We don't know what the end product is. We don't know what it's going to look like. What I do think, and I just want to endorse absolutely everything that Joanne has said, is, you know, I think the approach of marrying ethics with environmental governance, with activities, these should be a holistic approach to how we manage our space activity, because ultimately that's kind of the only way that people, we, get a say in space activity. The regulators are the face of us. They're the face of the people. And one of the things that I think is often missing, and one of the problems we have in space, is space belongs to them. We're talking about them. We're talking about big companies. We're talking about governments. We're talking about them. You know, astronauts in spacesuits climbing up the Saturn V. It belongs to them. It doesn't belong to us. And this is kind of where we get the problem with the environmental issue as well. People can't see it. So they're not badgering their representatives. You know, my local, if I walked around the corner and spoke to my MP about space debris, he'd say, well, you're the first person that's ever mentioned it to me. People don't have an ownership about it. So the information flow needs to be into the regulators, but I also think there needs to be, you know, we need to get out there and get a massive sort of education program about the dangers that we're facing. And this is where, again, I go back to Joanne's point about environmentalism as a whole. Space cannot only learn from environmentalism, it can actually be a trigger to further the discussion we have about how we treat the terrestrial environments as well. I'm sorry, Mark, I went on a bit of a rant there, but I think this is something that we can address, and it's within our gift to address.
Yeah. No, go on, John.
Can I just jump in there? Some of the best advice I ever got from the space agency is that if you want something changed, you need to make it relevant to the man who watches X Factor. We can't say that, no, actually, that's really, really sensible, because if we change the culture here, it's not out of sight, out of mind space. It affects us every day and all of us. And therefore, it needs to be mainstream. And I completely agree with Chris. We also need to feel ownership over that.
Yeah. A couple of questions that come in that have really been enlightened by the talk about promoting the race to the top. And in particular, is there any regulatory regimes in the US, France, or other states that would be most interesting for the UK to consider and adopt in terms of that race to the top?
So good question. The US actually have been taking this seriously for quite some time. I mean, they're known for applying their laws on an extraterritorial basis, but I thought that was incredible that this was 8 years ago, this statement that we will give you a terrestrial license from most of the states in the US, but we need you to comply with sustainable guidelines elsewhere and have a launching state that takes these guidelines and takes that liability for your satellites. So the US actually have really been taking this race to the top quite seriously. And actually, if you look at their licensing conditions, they've been applying the LTS guidelines and other guidelines for really some time now.
If I just jump in and say, and kind of add to that, one of the things that I've been waiting for with bated breath is the Chinese national space legislation to come through. We haven't seen that yet. At least I haven't seen it. I don't know if it's in existence. It's been threatening to come through the pipeline for about the last 2 or 3 years. But we know that China has a commercial space industry. We know that it's developing. We know that the Chinese private sector is expanding at a ferocious rate. I'll be really interested to look to the future to see how China are going to manage their commercial responsibilities and their national responsibilities as well.
Yeah. A question from Stuart Allen, who asked, how do you think the space sustainability rating might affect how companies behave in space now, and whether that can sort of be used as a trigger, I'm assuming, to move forward on some of the regulatory and behaviours questions?
Do you want to start with this, Chris, or shall I?
I'll let you go, because I know you have interesting things to say on this.
I think it's a really important and quite enlightening space sustainability rating, and I think it can be linked very nicely into this concept of ESG, because actually the LTS guidelines provide the lowest common denominator, but we do need to go further. And ESG, to be very blunt, is not the right term. It's linked into reporting requirements, but it's a good concept. So the sustainability rating can also look to this kite mark, this stamp of approval, which I'd like to see regulators exercise, which will also be very, very helpful for licensed entities to be able to raise finance. And just to finish on that race to the top, France also taken this very seriously, as of Japan.
Yeah, I think going back to my very first point, that we're talking about governance. We're not just talking about these levers that can move and influence behavior. I think something like the space sustainability rating, an index that points to good people and good practice, that's a lever that moves. And that's, we know that commercial pressure really, really does work.
Mm-hmm. Yeah. As the CAA begin to pick up the mantle and move forward on regulation, as we're about to finish, do you have any sort of little bits of a hint or a tip or a priority focus that the CAA might want to look at in particular? I'll start with you, Joanne, and then go to Chris.
I would like to see more engagement with industry as to what industry are doing, so it can take an anticipatory approach as to what's happening. And I'm going to come back to a soapbox, ensure cross-government alignment. And a multi-sectoral approach, multidisciplinary approach. And I think UK can be a leader here if it takes a step forward from the LTS guidelines.
Yeah.
Absolutely. Looking across the piece, we have a number of strengths in the UK. I'm going to say insurance, financial services. With the discussion that we're having here is not unrelated to those industries as well. So looking across the piece, not just being siloed, that's the way to go.
Yeah. Chris, Joanne, it's been fascinating. I've learned huge amounts as usual, and it's certainly one of those areas I mentioned in the introduction that has penetrated virtually every discussion on the panels we've had so far, and it's becoming increasingly important. And I know you two are right at the cutting edge of all of these discussions, which I'm sure become even more relevant as time goes on. So thank you both again for a great presentation, some great answers.
Thank you very much.
Thanks so much. Bye-bye.